Jury selection has now concluded in the James Crumbley trial, and now there's going to be opening statements beginning tomorrow on Thursday, and we will start to see the second case of its kind where a parent is being charged with involuntary manslaughter for the murder carried out by their minor children, or child in this case. So certainly this is news breaking. This is history in the making right now. Of course, not as significant as Jennifer's case because her case already was tried. She was convicted. So she already made the history. So this is already the second case of its kind, but still only the second case of its kind in all the entire United States history. And we will see if this trend continues to charge parents with the murder that their minor children carry out. So we will see. But anyway, James Crumbley's trial is slated to begin tomorrow. Jury selection concluded. And because, as I always tell my wonderful viewers and subscribers, and if you haven't yet, please subscribe, like the video so we can continue bringing you this analysis and getting the word out there. So as you all know, that I always feel that jury selection is so important. It can't be overstated and overstressed how important jury selection is. And it always surprises me how certain attorneys do not approach jury selection with the seriousness that they should be approaching it. There's been books and books written about how to go about jury selection, depending on what your case is, how to already start planting seeds and how to start explaining concepts to the jury to help them and to help you with your case and be able to explain to them what type of arguments they're going to be hearing and to see whether this is a type of juror that will side with you or not. So I think jury selection is so important. And certainly in a case like this, where it's one of the first of its kind, and especially when it's an involuntary manslaughter, which is also not such a simple charge, and there's a number of different elements and some legal concepts that really has to be explained, certainly it's a very important time, jury selection. So because that's how strongly I feel about jury selection in general, and certainly in this type of case, I decided that since this case is actually being tried in my backyard, this is a circuit court. The Oakland County Circuit Court is a court that I go to all the time. I have a number of cases there over the years, and cases that I've tried and in trial. And I decided that I'm going to go and actually be your eyes and ears in that courtroom, because jury selection is never televised. It's never live streamed, unfortunately, because it's such an important part of the process, and there's a lot usually to analyze. So I decided that just for you, I'm going to go and sit there and watch and take notes and then come back and be able to tell you and give you the real analysis of what's going on, what happened during jury selection. So got in my car this morning, went there nice, bright and early to the courthouse, got through security, went up to the second floor to Judge Matthews' courtroom. And as I was walking up to her courtroom, there were 3 deputies standing by her door. And they said, "Mr. Radner, we were waiting for you. Come with us." And I followed them to the back room, and the rest I can't discuss. No, I'm just joking. There are 3 deputies that were waiting there for me, but they said, "Unfortunately, we are not allowing anybody in the courtroom unless you are either a potential juror or if you are a recognized media outlet that already went through all the paperwork and filed all the appropriate paperwork and are on a specific list that they showed me. And if you're not on this list, you unfortunately cannot get access to the courtroom." So I was denied access, but I was able to follow some of the other media outlet personalities that were following this, and they did do what I hope is a decent job of reporting on some of the questions that were asked during jury selection, which I'm going to discuss with you today. And also what I'll also discuss with you is what certain questions that I would ask if I were sitting, certainly I think in the defense attorney's shoes, certain questions that I would be asking the jury to be able to start already planting the seeds in how I would be trying this case if I had to defend James Crumbley. So let me tell you some of the other interesting things that happened. So we have that the defense attorney filed a motion to change the venue in this case. They didn't want to try this case right in the heart of Michigan because that's where there's been a lot of media coverage, and there's so many people that already heard about it and been following the story that they don't feel that James Crumbley can have a fair trial and get a fair and impartial jury in this specific venue. So they asked to move the venue to a venue which is not so close to the school where the shooting happened. And the judge denied that motion, but the judge said that instead, what we're going to do is that normally each side is given a certain number of what we call preemptory challenges. When you're doing jury selection, you have two types of challenges where what we call them challenges really just means that you can dismiss a juror. That's what we call a challenge. So we just have to change it because, we have to change everything and make everything sound more complicated than it is. But it's really just when you're dismissing a juror. So there's two types of ways to dismiss a juror. Either what we call challenges for cause. Challenges for cause are when a juror is very clearly being biased or cannot be impartial in this case. That's one way to try. So then you can just challenge them for cause, and you have an unlimited amount of challenges for cause. If many times the judge will not agree with you on your challenge for cause, and they'll rehabilitate the juror, and they'll all the hard work that you went into asking this specific juror questions and showing how they're biased, the judge will say, well, can you be fair and impartial anyway? And usually the jurors say, yeah, of course I can. And there goes all your hard work. And they won't allow you to just use your challenges for cause that easily. And then you're going to be left with what we call preemptory challenges. Preemptory challenges are challenges that you can just use for any reason at all. You don't even have to give a reason. You just say, Your Honor, we'd like to thank and excuse juror number 4 or in seat number 4 or whatever. And then without any questions being asked, the juror is excused. So those are preemptory challenges. Now, there's of course a lot that goes into when you use preemptory challenges. What type of juror are you specifically looking for? What type of occupation, whether they're married, whether they have children, all these different things go into whether you decide when you're deciding what type of juror you want to have on your jury, depending if you're the prosecutor, the defense attorney. So those are preemptory challenges. So what the judge did in this case is the judge says what we're going to do is we're not going to change the venue, but we'll give each side more preemptory challenges. Normally you only get something like 5 preemptory challenges. Now we're going to be giving you more, something like 8. So you're going to get more preemptory challenges to use, and therefore to ensure that we're going to have a fair and impartial jury sitting on this case. And that's what happened. So that was number 1. Now, another thing that Judge Matthews said to the jurors is that she does have the ability to sequester the jury, and she can put them all up in a hotel, and they won't have access to anything that she doesn't want them to have access to. And she said, I could do that, but I'm not going to, because I trust you all that you're going to listen and follow my instructions, not to follow any type of media on this case or read anything about this case, and you're just going to be basing your decisions based solely on the evidence, facts, and law that comes out during this trial. So that was just a nice little speech that she was giving to the jury. You better be following my instructions, or maybe I'll just going to put you up in a hotel and cut you off from the rest of the world. All right. So I don't know if I said this, but the trial is expected to take 2 weeks, just like it did in Jennifer Crumbley's trial. A lot of the similar and same evidence is going to be coming in, but certainly new evidence is going to be coming in, probably specifically with the relationship between James and his son. We're not going to mention the shooter's name in this video. So those are some of the things. Now, obviously, when you are the prosecutor or the defense attorney in this case, the two main topics that, of course, you're going to want to cover with all of the jurors is what their feelings are with respect to guns, gun ownership, allowing children to use guns even at shooting ranges or in controlled environments. You're going to want to know people's feelings on guns. That's obviously going to give you a good look at how they're going to be viewing this situation that's coming out with the guns and everything that happened in the Crumbley case. So that's number 1. That's pretty obvious. Number 2, you're going to want to understand and talk to the the jurors about their feelings about mental health, or if they've had any experience with mental health. So, have they had their children with mental health issues, friends with mental health issues, and you're going to want to know what their perspective is on mental health. Some people feel it's a big hoax. Some people feel that everyone's overdiagnosed. Some people feel that no, it's underdiagnosed. People feel that everyone should should have a social worker or a psychologist that they're working with, or a therapist that they're working with. So you're also obviously going to want to understand that about your jury as well. So those are the main topics. So that's pretty obvious. So let's go into some of the questions. But before we get into the questions that the defense attorney asked, I want to talk about one of the questions that Judge Matthews, when the Judge Matthews was talking to one of the jurors, what came out during those questioning. Because a lot of times what happens is that the judge will ask some preliminary questions of all the jury members, and then after that she'll turn it over to the prosecutor and then the defense attorney, and then if new jurors are called, then there'll be more questioning. But a lot of times it'll start with the judge. And when the judge was talking to one of the potential jurors, this juror just completely went off, just unhinged. And the juror was saying how he feels that this is a travesty of justice, that they're charging the parents with this crime, even though it was a terrible travesty, a terrible tragedy that happened, but still they feel that this is just the prosecutor bowing to the mob, and this juror just went off unhinged. Now, this happens sometimes, by the way, during jury selection. This happens quite often on, sometimes, maybe I shouldn't say quite often, but it certainly happens where you're sitting there doing jury selection and all of a sudden a juror will just get up and start ranting and raving about everything that they feel. And but usually it's okay. It's usually the remedy is just to excuse that juror, and then the judge will talk to the jury and calm them down and say, look, we're only going to base our decision here based on the laws, on the rules of evidence, and on the facts, and the laws. I give it to you. So let's just calm down everybody and just ignore whatever just happened here. So that's most often what's going to happen in those situations. But I have personally been in these situations where the juror will just completely go off. But it's entertaining. But at the end of the day, I don't think it really affects too much. Even if the other jurors are listening, it doesn't really affect too much, I think. So let's get into some of the questions that Mirielle Lehman, this is the defense attorney for James Crumbley, some of the questions that she asked. Because you got to think, if you're the defense attorney in this case, what type of questions do you want to start asking the jury? And this is going to allow you to understand what type of arguments the defense attorney is going to be making, so that she's already sensing, and feeling out the jury how they would take to some of the arguments that she's going to make. So here's some of the questions that she asked. I got them written down. So here's some of the questions. One of the questions she asked of one of the jurors, is the only way to responsibly secure a gun by putting it in a safe? Is that the only way to responsibly secure a gun? And actually, the juror that she was speaking to said no. He agrees that there's other ways to secure a gun as well, and it doesn't have to be in a safe. So that may have been someone who the defense attorney is like, oh, okay, maybe I'll keep this guy on my jury. Another thing, if there are times when someone can be having a mental health crisis, is there a time when someone can be having a mental health crisis and you don't know about it? Is that possible? And some of the jurors responded, it depends. Sometimes you can know about it. Sometimes a person can be going through a mental health crisis that you don't really know about. The person looks pretty normal. Maybe they're just quiet, and they don't just always wear all of their feelings on their sleeve. So that was also important, because she wants to already let the jury know that it's possible. I mean, this is probably what we see coming, that it's possible that the shooter was going through some mental health problems, and the parent just didn't realize it, because this is something that sometimes we don't always realize, that someone's going through a mental health crisis. She asked, does anybody have any problem with parents taking teenagers to a shooting range? That's also a decent question, because that's what happened in this case. The shooter would go to a shooting range sometimes with his parents. Another thing, she asked a hypothetical. If a child took the keys to a car without his parents knowing about it, and then something happened, would you hold the parents responsible? Here, the parents didn't know about it. The son got the keys, and something terrible happened. The guy had a car crash or killed somebody in the car crash. Would you hold the parents responsible? That's a fair question to ask. You want to know what the jury, how much culpability are they going to say the parents the parents have in that type of scenario, because that's a similar thing would happen here. Then she had an interesting question. She said, raise your hand if you think that you're perfect parents. And of course, probably most people did not raise their hands. And then she asked, did any of you as parents make mistakes or wrong decisions? And of course, most people raised their hands. And then she said, well, raise your hand if you think that you're doing the best that you can. And of course, most people probably kept their hands raised. And that's kind of, again, what's the point of those questions? The point of those questions are just to laying seeds, planting seeds about this is the idea here, that they were not perfect parents, but they made mistakes just like everybody else, but they did the best that they could. Another question, because this also came up in the first trial. Should parents force affection on teenagers who don't want it? And anybody who has a teenager understands that when your teenager does not want affection, it's very difficult to try to force your affection on them. So that was also just a point to bring out, because this is something that they're going to be arguing, that you may not see so much affection between the parent and the shooter, but the shooter was a teenager, and teenagers usually do not love that type of affection. Another thing she said that you're going to see a video from the shooting inside Oxford High School. Now, the fact that this video is coming in is not such a simple matter why it should come in. Because really, if you think about it, why should this video come in? There can be a very strong argument that it's more prejudicial than it is probative. Because again, this is not the shooter's trial. This is the parents' trial. And the only question about is to the parents is if they were grossly negligent in allowing their son to somehow get a hold of the gun and then do this act. So why would there be any reason to have the video of the shooting be admitted into evidence? So this certainly, I'm sure of it, is a disputed fact. It's probably a motion in limine that was filed by the defense, and the judge is allowing it in probably for very limited purposes. And the argument, I believe, from watching the last trial is that they want to show that this shooter, the deliberate way in which he was going about, the confidence that he had in using a gun. And the reason why he had all that confidence was because the parents allowed him all this access to the gun, took him to shooting ranges, and that's how he got so comfortable with the gun. His stance at certain points and that's why they're essentially allowing this video in to prove that point. So again, you can make an argument, certainly for the defense, you can make an argument that, well, then there should only be clips of it, of him showing that stance, but not the actual. And again, we haven't seen this video, and they're not showing this video if you're watching it live streaming, but you don't know if the jury's actually seeing people get shot. If they're seeing actual people get shot, that should be, I'm sure, a strong argument for the defense that part should not come in. Just have the video of his stance coming in, or the way that he's shooting the gun come in. Well, maybe that is what happened, but we don't get to see, and I don't know if anybody wants to see really that shooting if you don't have to. I certainly don't. Okay, so she said, so again, this is part of the question. The question was, you're going to be seeing certain videos of the shooting. Do you understand that James Crumbley, who's on trial now, that you have to separate the shooting and what James Crumbley is being charged with? Because it's very easy to say, well, I'm going to conflate. It's very easy to conflate the two and say, well, if this happened, then James somehow is responsible for that. Then you'll somehow mix the two together. And she wants to very clearly separate the two and say, look, you're going to be looking at videos. It's going to be horrific. You're going to be seeing tragedy, but understand that James is a completely separate case from that actual shooting. So she wants to make that very clear from the get-go, which is a good point for her to do. Okay. Then she also asked, would you tell when you were teenagers, would you tell your parents something that was different from the truth? Would you hide things from your parents? And of course, anyone who's been a teenager would agree that they most likely hid stuff from their parents. And the idea here is that obviously the shooter here was hiding things from his parents, and the parents were not able to see or learn about certain behaviors or certain ways that he was acting and talking. That's part of what she's doing here. Another thing that she said, which is pretty common when you're the defense attorney, she said, James Crumbley right now is presumed innocent. So if I ask you right now, what's your verdict should be what? And then the jury will say, well, the verdict should be not guilty. Okay, good. You want to make that, you want to implant that in their heads that right now he's presumed innocent and he is not guilty until proven guilty. Okay, so a lot of very similar questions like that. Now, something that if it was me, if I was in the defense attorney's shoes in this case, the types of questions that I would be asking is, I want to make it very clear to the jury that there's a difference between, well, first of all, obviously, reasonable doubt. So you want to explain to the jury, and this is how I might go about it. I would say, Mr. Doe, John Doe, juror number 5. Some people don't think it's fair that the state has to prove their case beyond a reasonable doubt. That's the burden of proof in this case, that the prosecution has to prove their case beyond a reasonable doubt. And some people don't think that that's fair. Do you think that that's fair? And they may say yes or no. And that's something to follow up on. And then you want to keep stressing this. Well, juror number 6, there's different burdens of proof. There's a preponderance of the evidence. There is clear and convincing. Now, some people feel that clear and convincing should be enough. That should be enough to convict somebody. Is that how you feel? Do you feel that should be enough? And then if they say, yeah, I think that should be enough, then you say, well, do you understand that the law in the state of Michigan is that the prosecution has to prove their case not only by the preponderance of the evidence, not only by clear and convincing evidence, but they actually have to prove their case beyond a reasonable doubt. Do you just don't feel like that's fair? Do you think you'll be able to actually hold them to such a high burden? So that's something also that you want to, and I would assume that the defense attorney did this. I don't know for sure because I didn't get so much reporting about that, but I would assume that that's something that was done because you really want to stress that. Number 2, since this is an involuntary manslaughter case, and in Michigan, you have to prove gross negligence in order to be found guilty of involuntary manslaughter. This is something also that you want to talk to the jury about. You want to tell the jury, Mr. Juror number 8, it's just juror number 8. Do you understand? The judge is going to be reading to you a lot about different laws and elements that's involved in order to find my client guilty of involuntary manslaughter. One of those things is that you have to find that my client was grossly negligent. And I'm not going to get into all the elements right now, but one thing that I want you to understand is that there's a difference between negligent and grossly negligent. Negligent means that somebody is wrong. The person was 100% wrong. He didn't act with ordinary care. That's negligence. And if you find that my client was just plainly negligent in allowing his son to get a gun and to do this, will you still be able to come back and vote not guilty? If the law requires you to find that my client was not just negligent, but grossly negligent, which is a much higher burden, much higher standard than negligent, will you still be able to come back with a verdict that's not guilty if you just find that my client was negligent? And then again, you say, another juror, you just pick another juror maybe. Say, do you understand that if you find that my client was not a good parent and did a lot of things wrong, and that may have led to this murder happening, you still have to come back as not guilty? Do you understand that? Are you able to do that? it's very difficult because you may find that my client did a number of things wrong. But if it doesn't rise to the level of all the elements that the judge is going to advise you, instruct you about what grossly negligent is, you're required to come back with a verdict of not guilty. Are you going to be able to do that or not? So that's also something that you really, really want to stress in jury selection. I don't know if this was done from the reporting. I didn't see that it was done. And if it wasn't done in jury selection, as you all know already from my previous videos, you got to do it in opening statements and you got to do it in closing arguments, because this is a very important part. And this is something that the prosecutor doesn't want to focus on so much. So that is where we stand right now. That is the jury selection. If you haven't yet, please subscribe, like the video, and as you know, we are going to be bringing you some more trial analysis on the James Crumbley case. Opening statements start tomorrow, and we will see you next time.